Paul McHugh, born Gisborne, is a New Zealand academic lawyer. He teaches at the University of Cambridge, where he is a professor in law and legal history and fellow of Sydney Sussex College. He graduated LLB. Hons. from Victoria University of Wellington, LLM Saskatchewan, and obtained his PhD at Cambridge with his dissertation The Aboriginal Rights of the New Zealand Maori at Common Law, which was awarded a York Prize in 1988. It will be republished by Institute of Post-Treaty Settlements Office as a classic influential text. McHugh's work has primarily been in the field of common law Aboriginal rights, a topic on which he has published extensively. He is recognized as an authority on the legal status of tribal peoples in North America and Australasia, as both a doctrinal scholar and as a legal historian, as well as writer on the politics of historiography. His work on the doctrine of Aboriginal title in New Zealand argued that there remained unextinguished Maori rights around the coastline. The High Court accepted and cited his work in the Tiwi High Case 1986, leading to a series of cases in which New Zealand courts applied Maori customary law, recognizing it as the basis for Maori rights and exemption from the regulatory regime of the Fisheries Act 1988. His early academic reputation rests upon his pioneering work on the status of the common law doctrine of Aboriginal title, a field to which he returned after the Ngotiapa Case 2003 reactivated this debate in New Zealand. The court's judgments led to the foreshore and seabed controversy 2003-4, which fundamentally changed the course of New Zealand politics and ruptured the Maori Ratana movement's long-standing alliance with the Labour Party. McHugh is recognised as a leading authority on common law Aboriginal title and the legal character of tribal peoples' property rights throughout the common law world. It is believed the New Zealand government's willingness to settle the Maori Commercial Sea Fisheries Claim 1992 was directly attributable to McHugh's work and, associated with it, high-placed anxiety about an activist New Zealand Court of Appeal. The President Robin Cook, Baron Cook of Thorndon, as he became 1995, was known to hold a personal copy of McHugh's dissertation and in conversation with him, as well as having shown judicial mettle in the Maori Council cases of the time. Though based upon the claim to present unextinguished rights rather than those lost by colourable Crown conduct in the past, this was the country's first multi-million-dollar settlement of Maori claims in the modern era, and a foretaste of the claims settlement processes and asset transfers that followed and as contemplated by the Maori Council cases. McHugh is associated with the view that common law Aboriginal title was primarily a legal argument devised in Western Canada initially during the early 1970s and following decade to deal with the inaction of the political branches, their incapacity to legislate comprehensive land rights/claims regimes. McHugh was amongst a small group of lawyers/scholars during the 1980s: Brian Slattery, Kent McNeil, Henry Reynolds, Barbara Hocking, Richard Botlett, Tom Berger, to package Aboriginal title in a manner that became palatable to courts. He has been especially associated with its New Zealand dimension, as Justice Williamson acknowledged in Tiwi High, and as his influence both upon the activation and course of the foreshore and seabed controversy showed. He made considerable public lectures and practitioners' workshops in New Zealand during this period, and his work was regarded as influential at the highest political levels, including a half-day presentation to the Parliamentary Select Committee and Waitangi Tribunal. As the controversy waged particularly during the lifetime of the Clark Premiership and the fifth Labour government of New Zealand redrawing the country's political map, his published work returned to the more doctrinal orientation it had taken during his early career before his so-called Pukaki turn, described in Mark Hickford's important book Lords of the Land, Indigenous Property Rights and the Jurisprudence of Empire, Oxford University Press, Oxford, 2011 at 221.3, and Bernard Cadogan Treaty and Method online at this link. McHugh published the Maori Magna Carta 1991, which for the first time explained and analysed the range of laws specifically affecting the Maori in light of the Treaty of Waitangi. In the 1990s his work began incorporating a comparativist dimension, culminating in the publication in 2004 of Aboriginal Societies and the Common Law, A History of Sovereignty, Status and Self-Determination. The book picks up themes of his work in the previous decade, particularly the intellectual influence of John Pocock, Johns Hopkins University and R.A. Shop, Auckland, writer of Justice and the Maori 1990 and 1997. In particular, McHugh argues for the historicisation not just of legal doctrine, but of the notion of law itself, so that the history of the common law's encounter with tribal societies becomes also an expression of the change in the nature and modalities of legal thought. Further, the first half of the book considers the notion of sovereignty and how it developed in the Crown's dealings with non-Christian and tribal peoples from the medieval period. The second half of the book considers the modern history of Aboriginal rights, once they had been admitted into what he calls the common law right place as a result of key court judgments. All common law jurisdictions, Canada in 1973, the United States in 1978, New Zealand in 1986-91, and Australia in 1992 and 1996 experienced the impact of major court judgments dramatically reconfiguring state relations with the tribes. Thrust into the rights place, Aboriginal peoples have had to develop the legalism of life inside that habitat. This has presented issues of what McHugh terms right management, governance and integration, ongoing harmonisation/integration of Aboriginal rights with other rights such as those of municipalities, gender, resource licensees, environment, etc. In a series of papers from 1995, McHugh began considering the historiographical properties of legal thought and method and legal process, with Andrew Shop initiating a debate in New Zealand and Australia that has been continued by other academics and writers such as John Pocock, reproduced in his collection of essays The Discovery of Islands in 2005, W. H. Oliver, Bain Atwood and Giselle Bynes. The essay collection History's Power and Loss brings this work together, anchored by Pocock's essay. A more explicitly historical method appears in his published work from this time, with its insistence upon the careful historicisation, the placing in time and place not only of legal doctrine but also of the notions of legal obligation and the exercise of public authority at play in that setting. Hickford 2011 and Cadogan 2011 are clear that McHugh's position towards the history of common law Aboriginal rights is comfortably inside the mainstream of disciplinary practice in the writing of the history of political thought, as are important scholars in Australia such as Bain Atwood and Ian Hunter. Whilst uncontroversial and accepted intellectual fare in Australasia, McHugh's critique of Whiggish historical method in the conduct of contemporary Aboriginal claims-making in the courts and the shaping of historical narrative according to the predicates of present-day legal doctrine has become more controversial in Canada. As a result of recent judicial interpretation of Section 35 of the Canada Act, the Aboriginal Rights Provision, First Nations are bringing historical claims before Canadian courts. In New Zealand, this type of Aboriginal claim is subject to political resolution with limited court intervention, whilst in Australia the federal government does not admit such claims, with the Native Title Act 1993 processes being limited to accommodation of existing property and related claims. McHugh has also considered the constitutional basis of Crown relations with Maori outside of a claim-centred mode of engagement. A commissioned paper for the NZ Department of Justice published with another and a similar theme by Ken Coates as Aboriginal Identity and Relations in North America and Australasia. This paper, with its argument for the recognition of Crown and tribe in ongoing relations from which exit is not possible and finality and closure illusory, influenced the move towards more relational approaches in the public sphere, where Maori issues were to be seen in terms of living relationships rather than a sequence of problems to be eliminated. The language of closure and exit that dominated Paka-European discourse of Maori claims was predicated upon an outcome Maori emergence into a culturally undifferentiated populace that would never happen and which, in any event, was contrary to the treaty itself, and he might have added, the plain demographic pattern which strengthens rather than diminishes Polynesian profile. He has also written of the nature of constitutional memory and its manifestation in the New Zealand setting, as well as argued for a more sophisticated historiography of New Zealand legal history, a tradition that he believes has yet to take root. In 2004-06 he returned to common law Aboriginal title in the wake of the New Zealand foreshore and seabed controversy, when the court applied common law principles following the arguments pioneered in his published work in the 1980s. He appeared as an independent witness before the Waitangi Tribunal 2004, and the Select Committee hearings 2005, and toured the country under the aegis of the New Zealand Law Society explaining the legal position. In 2010 he appeared as expert witness before the Waitangi Tribunal on the Te Tai Mari, Kerikeri, explaining the legal basis of the British annexation of New Zealand. He has also been retained by the Canadian Department of Justice as an independent witness in several major land claims. His book Aboriginal title was published in 2011 Oxford University Press. The book is an intellectual history of the rise, spread and impact of the common law doctrine into the modern era of rights and their enforcement by courts. McHugh looks at the gestation, early formation and conceptualization of the doctrine in Western Canada through its articulation by scholars, adoption by courts there, in New Zealand and Australia as native title, its subsequent elaboration in Canadian and Australian case law, the busiest jurisdictions, through a proprietary paradigm located primarily and more constrictively inside adjudicative processes. From the millennium, forms of the doctrine also came to be applied by courts in Belize, Malaysia and Southern Africa. The doctrine also influenced the rapid development during the 1990s and after of the norms of Indigenous peoples' rights at international law. He looks at how the court's acceptance of the doctrine absorbed elements of surrounding public law values, including norms of non-discrimination absorbed from the international law covenants and civil rights movements, judicial wariness of unabridged executive discretion, the platform for the rise of common law judicial review from the 1970s, the rise of public interest litigation, and revised attitudes and practices towards amenability of the Crown to court proceedings. He also considers the issues of interdisciplinary thought and practice arising from national legal systems' recognition of Aboriginal land rights, including the emergent and associated themes of self-determination that surfaced more overtly during the 1990s and after. He has published also on constitutional identity in Anglo-settler societies in the late 19th and early 20th century. He is working on a new book 2016, Unremitting Solicitude, Crown, Tribes and Law in the Victorian Era. This develops the underlying theme of his 2004 book, calling for the careful historicization not only of legal doctrine but also and more fundamentally of the notion of law and the exercise of public authority. He is in considerable demand internationally to give public lectures and workshops on the rights of Aboriginal peoples in both an historical and present-day setting, in Canada and New Zealand especially, and is regarded as one of the most influential scholars in the field. His mother was Pauline Mary McHugh, died 1991. His father was Ashley George McHugh, died 1999, who became Deputy Chief Judge of the Maori Land Court and later chaired the Waitangi Tribunal's hearing of the Ngai Tahu Claim C Treaty of Waitangi Claims and Settlements. As of 2006, his civil partner is Andrew Hardwick, a film producer. His son Frankie was born November 2010.